In today's video, we're bringing you an exclusive interview with one of Ottawa's premier law firms founders, who's truly changing the game in an industry that's been done the same way for many, many years. Welcome back to the channel. My name is Norton Ngo. I'm a real estate agent here in the city of Ottawa. And if you find this video valuable or learn anything new, all I can ask is you hit that like button and subscribe to the channel. As well, if you have any questions on the market, you can book a call directly with me through the first link in the description. Let's get into it. So Alex is a founding member of ALX Legal and proudly practices in both official languages. Leading the real estate and development team at the office, Alex offers a complete service designed to build lasting relationships with his clients. Alex obtained his Juris Doctor at the University of Ottawa, Faculty of Law, before being called to the bar in Ontario in 2017. He's also equipped with a bachelor's degree in business economics from Providence College, where he was a student athlete with a men's hockey team. Welcome, Alex, and thanks for taking the time, man.
Thank you.
Yeah, I'm excited to have you, and I think you can bring a lot of value to our clients in terms of we've worked a lot of first-time homebuyer clients, and a lot of this content is really geared towards all types of listeners, but we get a lot of our first-time buyers and tenants out there that are looking into it. So appreciate it, man.
Yeah, my pleasure.
Awesome. So let's get into it. In terms of the first question, I'm very curious. Can you provide some context in terms to our listeners in terms of how the process of onboarding with the ALX law team works?
Yeah, for sure. So working with a lawyer is a mysterious kind of task especially for a first-time home buyer, or essentially anyone who hasn't bought a property in maybe say 5, 10, 15 years. The landscape changes continuously, but what's consistent is the process to retain a lawyer. So typically lawyers want to get retained officially by a client.
A commitment.
A commitment.
Yeah.
We call it just, a reciprocal engagement to collaborate on this transaction. No one works for anyone. You work together and you work towards a smooth closing, right? That's our tagline. So working with us kind of looks like an email introduction, just to get to know the parties. Typically attached to that email would be a copy of the agreement of purchase and sale. And that allows the lawyer to review the transaction, get familiar with it, and then circulate their retainer letter to formalize that engagement. Now, some lawyers choose not to get a formal retainer letter signed, but they simply confirm retainer by email or something like that. But I think best practice for both the client and the lawyer is to outline the respective responsibilities, because that way there's no misunderstandings. You understand what you're paying the lawyer for. You understand what's included in the scope of that work and what's not included in the scope of that work. So I always tell my team, think of the retainer letter kind of like the blueprint for the transaction, right? And so you address, like I mentioned, scope of work, fees that are related to that work, respective legal obligations, and anything that should be noted to the client, such as confidentiality and privacy of information, et cetera, et cetera.
Right. Okay, that's awesome. Because I think for a lot of clients, when they're first retaining a lawyer, cost is usually the first question, understandably, right?
Yeah.
But before we get into cost, can you really break into, during some of our real estate transactions, we've come across the question, why go with XYZ law firm, for example, right? Because this other one I have is cheaper, right? Can you elaborate for our clients and listeners in terms of how ALX Law, you guys bring value to your clients, and also the costs associated with a lawyer on the residential side? Yeah, and lastly, kind of how, ironically, you started the firm during COVID. So if you could break into that as well.
Sure,
yeah.
The first question we get is, why do I need a lawyer? Right. It's a good question because it's not as obvious as needing a realtor or a mortgage broker or a banker. The reason is pretty simple. You don't have a choice. So if you're on the buying side, you'll need a lawyer to administer the mortgage if you're getting financing, and you'll also need a lawyer to transfer title to the property. So title is the legal ownership of the property, and only lawyers have access to the land registry office to conduct these transfers of title. So that's the short answer. Practically speaking, what you want your lawyer to do is guide you throughout the transaction. And so if people are shopping, you need to understand what their priorities are. Is priority pricing? Is priority hand-holding? Is priority explaining everything, educating your client? And so having that conversation with your client from the outset is super important. if your client wants a cheap alternative, but also wants ongoing help and guidance, that might not be the best fit for a firm that doesn't have those resources. The client should also understand that you kind of get what you pay for, in terms that if you're saving a couple bucks, odds are you won't have someone there giving you daily updates on the matter.
100%.
The flip side's also most likely true. If you're paying a bit more, you should expect more. So you should expect daily updates. You should expect guidance through every step of the process. So for example, our firm, what we offer our clients is a guide, a step-by-step guide to that outlines the required steps for closing. We also have a team of our admin constantly available to answer questions, essentially on demand during office hours. And that way the client, even if they're kind of doing this on their own time, they can review their respective tasks and then consult with our team for questions. Now, while that's being done, the legal team in the background is actually conducting their tasks, like review of a status certificate, review of a title search, and then getting the file prepared for closing. And so my recommendation to any buyer out there is find out what your priorities are, ensure you understand what the lawyer is essentially promising in terms of scope of work within that retainer, and then that way you understand, you can make an educated decision on who you're hiring and why you're hiring them.
Right.
So for us, obviously when we launched the firm in 2020, March of 2020, I'd say a week or two right after the pandemic and the emergency was announced publicly.
Huge decision.
Yeah. Well, it'd been in the works for a while for us, but luckily we had a vision for the future of real estate services. Back then you'd have to meet with clients in person, have documents signed, the expression is wet ink signatures, and then submit those to lenders to fulfill funding conditions. We had the infrastructure ready for virtual services because we saw those coming down the road at some point. Now, the pandemic hits, physical distancing is encouraged. No one knows if banks are closing. And so we just had to pivot overnight. Luckily, our retainer letters are all sent virtually, signed digitally. Our intake forms to collect information from our clients are all, again, circulated virtually, filled in a secure encrypted platform, and we were able to offer virtual meetings with DocuSign signatures. And so all of those elements were outlined in our retainer letter, so our client knew what to expect. It's not like the client was hung out to dry, not knowing whether or not their deal was going to close, whether they're going to meet in person. Some people were quite hesitant to
meet in person.
To meet in person for obvious reasons. And so it kind of goes full circle with what I was saying earlier. Understand what it is that you're paying for, because you may be comparing retainers and, you know, a cheaper alternative might be appealing, but then when you see what's included, some people might be ready to pay a couple $100 extra to get those benefits.
The true full service. 'Cause
Yeah.
I think that's a big thing, is that often comparing price, as they should, but more so understanding what their vested interests, as in the lawyer, what their vested interest is, and supporting you. You know, the element of, you know, you can't pay a discounted service and expect premium VIP service, right?
Yeah, and I think one thing that's becoming increasingly popular in the industry is offering different packages, like a base package, kind of a middle ground package, and a white glove service. But the way our office kind of sees those services is we're going to offer you premium no matter what, because that's how we think these transactions should be handled. And if you don't see the value in that, then we're just not the right fit.
Right. It's a true premium service, right?
Yeah.
So I find that oftentimes with first-time home buyers, it's an element of perhaps it was a very smooth transaction, ideally with the pre-approval, with the real estate side. They have a purchase agreement that's now firm and binding. In some cases, it'd be unfortunate to have, you know, a smooth transaction be spoiled at the end, arguably at the most exciting time, right?
Yeah.
Where it's kind of just more pushing paperwork at the end and sign these papers now.
Exactly. Yeah.
Which is unfortunate, right? Because where it leaves a bit of a stain on the transaction. Would you agree?
Absolutely. Yeah, absolutely. It's ironic that the lawyer is the last piece of the puzzle. You would think that lawyers would get involved a bit sooner in the process. And I think we are seeing versions of that in some circumstances where solicitor review clauses are included in the agreement of purchase and sale. You certainly see it in new build purchases where the lawyer takes a look at the agreement of purchase and sale. But for us, we see it as an extension of the realtor service and of the broker service. And so if you have a realtor or a broker offering a certain type of service, you want to at least mimic that in a sense, have the same kind of brand applied to it so that it's seamless for the client.
Right. I always say that, you know, we're all pulling on the same rope into the same direction, ideally, right? In the sense that we've all worked together. You know that everybody else is accountable to kind of the service and response time. If your lawyer is very responsive, but your realtor is taking a day and a half to answer your questions, it doesn't mimic the element of, like you said, a white glove service on all fronts, right?
Yeah, exactly. I think when people are kind of exploring the landscape for legal services, they should definitely trust their realtor and their broker for multiple reasons. One, collaboration. Yeah. That's huge. If you have a realtor who's never worked with a law office before, there may be some discrepancies there in terms of getting along for closing, collaborating. But if your realtor's worked with this law office before, and the same goes for a mortgage broker, the process should be seamless. Their clerks know each other. The professionals know each other. They probably have each other on speed dial, et cetera. Yep. And so that's added value that you won't necessarily see in a fee or in a scope of work as 100%. Well.
No, that's awesome. In terms of lawyers, I often find that lawyers are that part of the transaction that, like you said earlier, is a bit mysterious in the sense that not everybody's aware of their full scope of services or work. Can you break down for our listeners what the relationship and process would look like amongst lawyers? So a buyer's lawyer and a seller's lawyer.
Yeah.
I think that's very key for our listeners. So if you could break that down.
I think a common misconception is that lawyers are competing against each other. And when things go wrong, sure, that might be the case. But in most cases, lawyers work together. So in Ontario, we have caveat emptor, which is Latin for buyer beware. So it's always the buyer's responsibility to satisfy themselves that they're making a good purchase. And so the buyer's lawyer is always responsible for due diligence, whether that's reviewing a status certificate and advising the buyer, whether it's a title search, sometimes due diligence against the sellers themselves for writ searches and court orders and stuff like that, just to make sure that by the time you get to the closing date that you're not dealing with any issues. You can proceed with the transfer of title and get your clients the keys on the buying side. The sale side, ironically, is much simpler for a lawyer. You receive a letter from the buyer's lawyer called the requisition letter, outlining any issues that have been discovered during the due diligence process. And then you, as the seller's lawyer, you need to collaborate with your client to rectify any of those issues.
Right.
Aside from that, you advise your client on their obligations to leave the property vacant or transfer leases if the buyer's assuming any tenancies. And then also your task as the seller's lawyer is to discharge the mortgage. And so although the lawyers have respective tasks along the way, the tasks are intertwined, right? Due diligence is intertwined with the requisition letter. On closing, both the buyer's lawyer and the seller's lawyer need to sign off on the transfer of title. There's an exchange of funds, an exchange of signed documents, keys in some cases, or a code to a lockbox. Those are all elements that are held in escrow until the closing can occur. And so for buyers and sellers out there not knowing what their lawyers are doing, essentially what they're doing is they're protecting their respective clients' interests while collaborating in an effort to smoothen that transaction as best as possible.
Right. And it's collaborative, like you said. You're working together so that everybody gets a mutually beneficial result, right?
Exactly.
And further to that, can you kind of elaborate on the relationship between a lawyer and the financial institution that's involved, right, on the buyer side? So I think that's also a big misconception that a lot of people, they're approved for the mortgage, they have a legal representative, but how does that shake out on the back end? So if you could dive into that as well.
So that's one of the reasons you need a lawyer. you need the lawyer to administer the mortgage. And what that means is that the lawyer, although retained by a buyer, in most cases in the residential world, they're also retained by the lender. So let's say I have a client who's buying a property, their financing is with TD. TD will retain me to administer the mortgage. And so what that does is it creates a joint retainer. So a buyer should be advised of the nature of a joint retainer. What that means is you're collaborating with two different clients with the same goal in mind,
right,
which is the administration of the mortgage, the fulfillment of funding conditions, and then the disbursement of those funds on closing to purchase the real estate. And so while I'm collaborating with either the bank or a mortgage broker, what we're doing there is we're satisfying the lender's conditions, whether that be due diligence against the property, due diligence against the borrowers, the execution of closing documents, such as a loan agreement, sometimes pre-authorized debit forms for mortgage payments. The list goes on and on. But in theory, what the lawyer there is doing is ensuring that both parties are getting what they bargained for. So the borrower is getting those funds on time, and the lender is also getting the security that is required for that loan. In other words, registering that against real estate, making sure they're in first rank on title, and that the borrowers don't have any liens or encumbrances on their personal names either.
For all parties to a real estate transaction, oftentimes, especially first-time homebuyers, it all leads up to closing day as that big day, right? So can you walk our viewers and clients through leading up to closing day, what that would look like? And on the actual day of closing, what steps are taken by the ALX team to really kind of make it a smooth transition, like we said, in terms of a white glove service? Yeah.
What I tell my clients, I usually meet my clients a few days ahead of closing. What I tell them is, ironically, we've done all the work already. And so closing is a lot of waiting around, and it's due to this, what I call the domino effect of the closing date. And so what needs to happen on closing is the buyer needs to fulfill their conditions for funding. That should be done a few days ahead of time. That gets you on top of that lender's list to get funded that day, or as early as possible. Once the buyer's lawyer has the mortgage proceeds in trust, they should already have their client's down payment and adjustments, and essentially what we call the closing costs in trust ready to go as well. At that time, you wire the funds to the seller's lawyer's office, and then the seller's lawyer reviews everything, reviews the signed documents, reviews the funds, and then signs off on the transfer of title. The buyer's lawyer also needs to sign off on the transfer of title, and then the buyer's lawyer registers it, and that's your closing. And so some people ask me, when can I expect to get my keys on closing? And the answer is always the same. We don't know. Ideally, we want to get you keys as early as possible, but once you understand the domino effect, you can't really predict when that transaction is going to close. When are we going to get funded by the lender on the buyer's side? How long is that wire going to take to get to the seller's lawyer's trust account? Is the seller's lawyer in a meeting at 1 p.m. or 2 p.m. with another client? Can they review the signed documents and ensure that the funds have hit their trust account? What I tell my clients is be patient on the closing date. It's a lot of waiting around, but if everything goes well, we'll close before 5 p.m.
Yeah.
The land and registry office dictates when the deal can close, because we need to be able to transfer title in their system, and their system's only open until 5 p.m.
5 p.m. Yeah, because that's often a misconception. I feel I can totally relate to when that's your most common question is, when do I get my keys? But where we often tell our clients, like, to alleviate stress, work that day, really, in
100%.
terms of where your day is going to go by a whole lot faster.
There's no reason not to work.
As opposed to, your moving truck, you're not booking at 2 p.m. anyways, right? So,
exactly.
That makes it a lot smoother as well. To each their own, though. For us, we often like to say real estate transactions, we want to alleviate from the beginning any surprises and ensure they're prepared throughout the process, right? So for your team, having worked with many first-time homebuyers over the years, in the marketplace, what would you say are some closing costs that are often overlooked or maybe not anticipated by your clients?
Yeah, the obvious ones are your down payment, your legal fees. I would say the ones that are overlooked sometimes are land transfer tax. Yeah. Ironically, that's usually your biggest closing cost. If you're a first-time home buyer, you most likely will qualify for a $4,000 exemption. Yeah. But nowadays, with the average purchase price, it's not covering the whole thing. No. A few years ago, it would cover a big chunk of it, if not all of it. Nowadays, we're seeing first-time home buyers buy, in the $700,000 to $900,000 range and have that cover maybe only 50% of it. So I'd say understanding your land transfer tax, understanding your legal costs, and not just the fee the lawyer is charging, but the entire cost of it. And I think that's another issue with lawyers quoting nowadays is they'll give you their fee, but they won't give you the all-in, right? And so a lawyer's invoice is comprised of a fee, disbursements, which are out-of-pocket expenses incurred by the firm, and then HST. So if a lawyer tells you, I can do this deal for $1,000, it's not going to cost you $1,000.
Misleading in some cases.
Exactly. Yeah. You need to understand that it's the fee, the disbursements, the HST, what's included in your disbursements. Does that include title insurance? Does it include a full title search? Because if you get a lawyer that's quoting you on everything, you'll be able to crunch the numbers and figure out cost certainty on closing.
Budget accordingly. That's awesome. And to kind of, in wrapping up closing, can you explain the term caveat emptor? And in a case where a purchaser runs into some issues or there's a surprise on closing that we're talking about, what would be a tool that could be utilized? And maybe an example of kind of how a law firm would rectify that as well.
Yeah, caveat emptor, we touched on it briefly. It means buyer beware. So the buyer is responsible to conduct due diligence against the property. That could be in the form of a status certificate review, title search review, which the lawyer takes care of. But it does go a step further. That's why you need a realtor and a lawyer who can collaborate. Let's say you have a final walkthrough and there's issues with the property that weren't there at the moment the agreement of purchase and sale was signed. What do? Let's say you've got issues with the seller not being able to close for a reason or another. Maybe the tenant hasn't vacated the property. Maybe there's been an accident, such as a flood or a fire. How can a buyer's lawyer protect their client in a situation where the property that's been bargained for is no longer in the same condition? Well, one, you conduct the searches just to make sure that physically the property is in the same condition, inspection, final walkthrough, and the lawyer should on their end conduct the searches for the legal aspects of the property. One item that people overlook often is title insurance, and title insurance covers the actual ownership of the property. Ironically, title insurance is an insurance for the title, right? And so what that does is, one, it protects the buyer's ownership to title against fraud, against third-party impersonation of the seller, and et cetera, et cetera. But it goes a step further as well. What it does is it limits the scope of the lawyer's searches. And so if a lawyer doesn't need to conduct off-title searches, such as fire work orders from the local fire station, work orders against the property, such as failure to order a permit to build a fence from municipal authorities, environmental issues, the list goes on. And so if you're retaining a lawyer to conduct all of those off-title searches, one, they'll take weeks, if not months, to conduct, and it'll cost you a fortune. And so with the introduction of title insurance, the insurance company insures the buyer against those risks. Right. And so it replaces the need for those off-title searches. A lawyer is still going to conduct on-title searches. And so anything that's discoverable on title insurance will not cover, and that'll fall upon the buyer's lawyer to draw that to their client's attention and rectify prior to closing. But title insurance does cover those legal aspects that could be at risk for the buyer. And so in terms of legal, title insurance, good review of status certificate and title search. In terms of the physical state of the property, an inspection, a final walkthrough. And then to protect the buyer from an issue, then the parties can negotiate a holdback. And so the idea of a holdback is that, let's say, for example, that some of the appliances aren't working, and the seller made representations to the buyer that those elements would be functioning on closing. Well, the parties can agree, and the parties would have to agree, because it wouldn't be provided for in the agreement of purchase and sale, that the seller acknowledges that some of the appliances are no longer working. It's their responsibility. Let's negotiate a $2,000 holdback to have those appliances serviced and fixed at the cost of the seller. And then upon the issuance of an invoice, those invoices would be paid from the funds that are being held back. And that way the buyer is not at risk. And the the closing doesn't need to be extended. You can close as scheduled, and then the funds are being held back to secure the seller's obligations.
That's awesome. Because we actually ran into, early on in my real estate journey that a holdback came about, and where it was very helpful, like you said, to have somebody that you can call and ask them how that process goes about, right? So that's awesome.
Yeah, absolutely. Part of a lawyer's scope of work also is taking care of those issues. Some lawyers will often delegate those tasks to maybe a litigator. And so understanding like what is your real estate lawyer's capacity when things don't go as planned? Can they handle those small issues? Are they going to refer the file out right away to a litigator and then have the buyer incur additional fees for that? And so that kind of falls within the scope of work. Like, what would the lawyer do for you if things aren't going as planned? Or is that going to cost me extra? Having that conversation with a lawyer from the outset is a good idea.
Absolutely. It's not a problem until it's a problem. Right?
Exactly.
To jump onto our next topic in terms of new construction. So what would you say are some of the common differences from the resale versus new construction space when closing from a legal perspective? Such as reviewing the purchase agreement, like as an example, and also what are some noteworthy clauses or tips that you would have to protect our clients out there that are looking into the prospects of looking into new construction?
I'd say the biggest difference between Form 100, the OREB Form 100, for example, in a builder's agreement of purchase and sale, ironically, is the form itself, right? Like, it's not a preset form that protects each party. When you're dealing with a builder, anything can be in that contract. Typically, what you'll see is you'll have the notion of HST in there. New construction properties are subject to HST, and assignment prohibition. And so when you're dealing with Form 100, you can assign that unless there's linkage to the contrary. A builder will not let you assign that type of transaction because, one, they don't want to compete with you, and they also want to be able to charge an assignment fee if they do consent to the assignment of that contract. In terms of HST, it's important to understand how HST is reflected on your agreement of purchase and sale. Builders will include HST in your purchase price. The purchase price that is advertised for that property will be inclusive of HST, but it will also be inclusive of HST rebates. And so in Ontario, there is a provincial rebate and also a federal rebate for properties being sold. And what builders will always do is they'll assume that you're qualifying for that rebate. And essentially what that assumes is that you'll occupy the property on closing. That is typically what I draw to my client's attention when they reach out to me with an agreement of purchase and sale from a builder. Are you going to occupy that on closing? If the answer is yes, well, there's no actionable item on their end unless their situation changes. If their situation does change or they have the intention of leasing out that property as a landlord, the provincial rebate will not apply.
Right.
The federal rebate will not apply on closing either, and they will have to pay that on closing and then apply to the CRA for that rebate if they're able to show that they've created housing, so that they've got a lease agreement in place with the tenant, and they've created housing for the public.
Right. That's very helpful because I think for somebody that they intended on occupying it and then now they're renting it, that's cash on closing that they have to be cognizant of. Right?
Exactly. Nowadays, you're looking at something like a $24,000 provincial rebate as soon as you reach $450,000 purchase price. And so in most cases, that's the range we see new build properties go for. And so if you don't have that $24,000 available on closing, you're not closing.
Which is no small sum.
You need to know exactly. And you need to know that from the outset. You can't know that a week before closing.
And we've heard some turmoil in the residential new construction space in terms of, say purchasers that signed at a very frothy time in the market, and now it comes time to close, and the property is actually appraised lower, and they can't obtain financing per se. Can you provide some context to our listeners in terms of how to approach these types of instances and the ramifications that are at stake in terms of if they were to not close on that property?
Yeah, that's a very frequent scenario. We're seeing that becoming an issue in Ontario. I think there was a period in time where buyers would essentially sign an agreement on purchase and sale, assuming they could assign it down the road. The assignment is then either rejected from the builder or there's no assignee willing to take on that transaction. And so they're left with a contract to purchase real estate that they can't afford. Another common scenario is where they might own a property, they're banking on selling it in order to purchase their new one, and the property they already owned sells for much lower than anticipated, and so they don't have the funds to close. I think this is probably the most obvious answer possible, but like, don't get yourself in that situation. Right. You know, if you could prevent signing a contract that you know you might not be able to fulfill, it's not worth signing. Now, if you find yourself in that scenario and it's already too late, my first piece of recommendation is speak with the builder, see if they would consent to an assignment, if they would consent to the extension of the completion date. Maybe you can extend that to a later date where rates are lower, where the value of your property, if you're selling it, increases, where you can find alternative financing to complete your legal obligations under that contract. And otherwise, what you're facing is breach of contract, and then retain legal advice to understand what it is that you are responsible for.
Right.
And so in Ontario, the basic of those rules is the seller has to mitigate damages. And so they need to limit their, exactly, being the builder. And so resell the property. And if, for example, you're buying for $750 and the builder resells for $650, you're on the hook for $100,000.
Right.
So we're seeing ongoing litigation, and this is not the type of litigation that is really subject to change. We have case law that that is clear. If you breach a contract that you've entered into, you are responsible for those obligations. And so again, if you can be wise enough not to put yourself in that risky situation from the outset, that's the best case.
Right.
So, if not, well, look at the alternative options that I just listed.
100%. And then, this isn't necessarily as, we haven't seen it here in Ottawa, but in terms of pre-construction fires, we're seeing some of these cases pop up within the GTA, the Greater Toronto Area. From strictly a legal perspective, how would this be looked at? And say you had a buyer that was actually affected by this. How would you be counseling them in terms of, it's a stressful scenario, right? The house that you purchased is now either delayed or it's an insurance process as well, right? So from strictly a legal perspective, how would you look at that? Yeah.
So I had a client in a similar situation a few years ago. This was a house that exploded in Orleans. It was a new built house that exploded. Their house was relatively new, backing onto this property. Right. And so the back part of it got torched. And then the firefighters came in and drenched the whole kitchen. Right. So there was significant damage. The options for a buyer in those circumstances is, well, you got to get an inspection done to understand the scope of the work that's needed. Obviously, insurance is involved, and they will usually conduct some form of a remediation report. The buyer should consult with the insurance provider and with the remediation teams, and they have an option. They have an option to collect the insurance proceeds, or to close, or to simply let the insurance companies remediate the issue. So in that case, what we did, my clients decided to close on time, not extend the closing, let the companies fix everything, and then we did negotiate a holdback to secure some obligations that may or may not have been covered by insurance. Right. And so buyers need to be wary that that's not something that happens overnight. If you are agreeing to close on time and then just letting these contractors fix the house, you need to understand it could take a long time. In this case, it took almost a year, but the seller's promises were fulfilled, and we need to also understand that the sellers weren't the ones that started the fire. It was just an accident that happened in the neighborhood, and then it just put all the parties in a kind of a weird situation. And so, my recommendation to a buyer is just retain a lawyer, get sound legal advice for that. Make sure you understand the pros and the cons of the situation. Depending on the circumstances, choose what's best for you and your family, and ensure that there's some type of security negotiated between the parties to I guess, motivate them to fulfill their undertakings, their legal promises.
Right, because like you said, I think that it's very important for any buyer, whether it's GTA or here in Ottawa, to be cognizant that it's, in a lot of cases, an extremely drawn out process. Right after that happens, right, with lots of third parties. In terms of our next topic, more market conditions. What are you and your team seeing in the residential space? I know you guys do lots of residential transactions. As we wrap up, a very eventful 2023 with elevated interest rates and overall in the marketplace, less transactions. What are you guys kind of seeing from the ground level?
We're seeing that as well. We're seeing lower volumes of transactions, but I think the most common theme from a legal perspective is breach of contract. Unfortunately, I think a lot of buyers and sellers out there are relying on the sale of their property to purchase another one. And so when you sign an agreement of purchase and sale to purchase a home and you're relying on the sale of your property and it doesn't sell, what then? We're seeing also a domino effect whereby a seller sells their home, then decides to buy another one, but then the buyer of their house defaults, and so they
Domino
in turn
effect.
default on
Domino
their
effect.
purchase.
Domino effect.
Yeah, the domino effect of contract breaches. There's no magic solution to that other than don't buy a property unless you've sold yours. And even in a sale firm, nothing guarantees that the buyer is going to close on your deal. I think there are solutions to that. I think bridge financing is a good solution. Closing your purchase before your sale might be a solution in that sense. You pay for bridge financing, you close on your purchase transaction, and then if ever the buyer of your sale property defaults, well, they would be responsible for any of your damages, which would include additional interest on your bridge loan. It's not a perfect solution. I always tell my clients, even though you have recourse, it doesn't mean that that's ideal. You still need to go to court, claim damages, or settle with the defaulting party. And so my recommendation really, again, is just, depending on your circumstances, try not to gamble. Like, speak with your professionals, come up with a plan. Never assume that things are going to go as planned either. Never assume that you're going to be able to sell your property for a certain amount. Right. Project for conservatively for the worst case scenario, and then see what that looks like before you sign an agreement or like a legal obligation to purchase real estate.
Absolutely. I think that's really helpful. And I think that this next question will give some context in terms of, the market when we first met, in terms of, can you provide some insight to our listeners in terms of understanding maybe 4 big differences in the residential resale market from a legal perspective, dating back to the frenzy market that we had. So call it that 2020, 21, and 22 market. What are 4 major differences you would say that you're seeing compared to today?
The biggest difference is conditions. A few years ago, and this was a nightmare for lawyers, seeing an agreement of purchase and sale come across your desk with no conditions, no inspection, no financing, no insurance. And I've seen scenarios where all 3 of those issues led to breaches from my clients. And so, I got a pre-approval, but then a few weeks prior to closing, I lost my job and I couldn't close. Same idea with the inspection. I close on the house, I figure out there's $25,000 worth of mold remediation to do. What's my recourse? You've got nothing. And so that's the biggest difference we've seen, is with less demand, people aren't competing for houses as much as they used to, and so you're able to introduce some conditions in your agreement of purchase and sale. I think that's good for the market. That's good for buyers. It's good for the court system as well. We're seeing more reasonable delays for closing as well. So 3-4 week closing turnarounds aren't as common anymore. We're seeing the standard, 8 week turnaround on deals, which is,
I think that's better for everybody.
It's better for everyone, definitely. Lawyers need time to properly do their job. 4 weeks is fine, especially if you're an efficient team. But when you're getting into like a 2-3 week turnaround, and you're collaborating with a lawyer that might not be as available as you are, the clients might feel the effects of that.
Absolutely.
Yeah.
It's reflected in the sense that perhaps one party's doing their job, but the other, really, it's you can only control what you're directly controlling, right?
Yeah. The last thing that I'd like to add to that is offer dates. And so my recommendation a few years ago when clients were getting ready for offer date was, if it's a condo, I need to review that status certificate ahead of time. You can't just buy a condo and expect to not assume risks or rules or bylaws that might not be appropriate for your situation. Like if you own a pet and the condo doesn't allow pets and you don't look into the status certificate before submitting an offer, you might find yourself in breach of your condo rules and having to get rid of your dog.
Yeah, or condo fees going from $500 to $700.
That as well. Yeah.
Thanks for providing that context. This next question, it is unfortunate, but like I read a stat that over the past 3 years, we've actually seen a large spike in terms of divorces and separations for a number of reasons, of course. But and I know you're not a family attorney, but from strictly a real estate side, real estate law, how would you walk through that side of the transaction if it's one of your clients going through that?
Yeah, I've seen this often. The first thing the parties need to figure out is, what are they doing with the house? If they agree on the sale of the property, it's a pretty standard sale transaction. The sale proceeds would form part of their net value, and then the family law lawyers would factor that into their calculations for equalization payment. If the parties can't agree on the house, then litigation might ensue. But in my experience, in most cases, that is settled pretty early, either via separation agreement, either mutually between the parties. But my first piece of advice when I have a client in that situation is consult a family law lawyer.
Right.
I can execute any real estate transaction from there, but they're usually pursuant to a separation agreement. And so speak with a professional, get the sound legal advice you need to feel comfortable with the next steps. And then once the parties have agreed on that and have signed a separation agreement, I'm in a position to fulfill that transaction.
Right.
Those transactions, as you can imagine, are pretty touchy.
Yeah.
Some people get along great in those circumstances, some people don't. And so my recommendation to any lawyers in that situation is just offer separate meetings, offer flexibility. It's a very stressful time for them. And then learn how to collaborate with the family law lawyers as well.
Absolutely. And I'm sure you guys can refer our clients to anybody that they're looking for those type of services.
Of course. Yeah.
Awesome. With elevated interest rates across the country, we're seeing more and more tenant-occupied properties come up for sale, right? And we know that those are in some cases more challenging to sell and get to market. But from a legal perspective, how would you advise a buyer in the sense that there's a property they purchased and the tenant refuses to move out once the property's closing? Of course, their realtor should be providing them guidance on the risk, but from a legal perspective, what occurs when they purchase a tenant-occupied property?
A lot of that goes into the underlying contract, so the agreement of purchase and sale. What's the language that was included in there? The clause you'll want as a buyer is vacant possession of the property on closing. That usually comes with a representation from the seller that they will serve the tenant with the landlord and tenant board documents that are required for eviction, typically an N12 or typically an N11. So as a lawyer, I like seeing the N11 simply because you have a buyer or a tenant and a landlord acknowledging that the tenancy has been terminated. The provisions, the deal for that are always different. Sometimes the landlord will offer a sum of money in exchange for that. Cash for keys, exactly. In exchange for that signature. In that way, enforcement of the N11 is a lot easier. You don't need to schedule a hearing with the landlord-tenant board. Eviction can be done directly with the sheriff's office. The N12 is where you see that type of scenario where the seller has advised their tenant that they are selling the property, that the buyer needs access to the property for their personal use, and so they're evicting them for that reason. If a buyer has signed an agreement to purchase and sell that doesn't require vacant access or vacant use of the property, they might have to assume that tenancy. Assuming that's not the case, you're looking at a tedious process with the landlord and tenant board to get that tenant evicted.
Yeah, it's tough because, like, you know what, it gets into the element of, I actually saw it on the news. It happened here in Ottawa. Like, I think it was about a month ago. It happened here in Ottawa, but it's such a drawn out process that it's almost a bit of a broken process in the sense that you're buying a tenant occupied property and you're committing to this as your house, and you're not able to be provided housing, right? Because they can really drag out that process.
Yeah,
there, right?
absolutely. I think the pandemic and the government intervention that ensued really clogged up the system, where tenants understood that they didn't have to pay their rent and then caught on that eviction for a landlord is extremely difficult.
Absolutely.
So if I had to criticize government intervention, that's where I'd lay the blame there.
Right. Well, it's tough, right? Because somebody rented a house in 2017 and the same house rents for, $450 more today.
Yeah.
If not more, right? It's tough for them. I can understand the tenant's point of view, but it's also very tough on a buyer that's committing to a new home, right?
Yeah, exactly. I mean, all the circumstances are different in each case. You've got rent control that's been reintroduced a few years ago. Obviously, the pandemic was hard for everyone, so I do appreciate that some people couldn't afford rent. But when you have this phenomenon where tenants are refusing to pay rent, knowing that there will be no consequences, that's what happens with the landlord and tenant board. It gets very clogged up. But my recommendation to buyers looking at tenancies, whether it's a duplex or triplex, is like just get the N11.
Yeah.
If not, it's not worth buying. Yeah. And I think we have seen an effect on demand for those types of properties.
Absolutely.
I think a lot of buyers are hesitant now that they know how those things are handled at the landlord-tenant board. But yeah, without that N11, I would be advising my client not to.
You just don't control your fate, right? You don't control what you do with that tenant, right?
Yeah.
So that's awesome. This actually came from one of my friends when we asked for a set of questions. Are bank foreclosures on the rise here in Ottawa, and are you seeing more come across your desk? I know you mentioned some more difficulties in terms of not being able to close, but or maybe they purchased another one and the proceeds are not what they expected. But are bank foreclosures on the rise here in Ottawa?
I don't typically get involved in that type of process. I would say personally, and this is just obviously a very small very small sample size, but I would say no. I think most people will sell the property before they get into that situation. Ironically, I've seen more in the past years than I've seen this year. People typically tend to allocate their resources to their principal residence first over anything else. And so I think when people are having issues affording that, they'll sell the property, protect their equity, knowing that foreclosure or private sale proceedings with banks might jeopardize the equity they have in their house. Absolutely. So they'd rather control that process themselves, sell it for what they think it's worth, and protect their investment in the property rather than just letting the bank seize possession and sell just to essentially recuperate their investment in the property, which is the mortgage.
And then the next topic we have more so in terms of knowledge-based for our consumers out there. I believe the public should know in terms of being well coached on the true legal ramifications of not closing, right? So when a purchase goes firm and binding, can we use an example of, say, buyer, they fulfilled their conditions. Say it's a financing condition, they fulfilled that, and now at closing they have cold feet. Something came about, and they're not looking to close. Can you? I know you touched on it a little bit before, but on the resale side, how that would look if they're not closing.
Yeah, so let's say I've got a client selling a property. Buyer was given a condition to fulfill financing, fulfill that condition, and now has cold feet as we approach closing. My first recommendation to my client here is you got to relist the property. You got to mitigate damages. In order to do that, you need an acknowledgement from the buyer's lawyer that their client is in what we call anticipatory breach. Or you need that closing date to essentially to render the agreement null and void, subject to the breach of the buyer. And so you can't just relist at any time. You really need to understand when it is that you can relist. but typically your lawyer would get a letter or confirmation in writing from the buyer's lawyer that the buyer is no longer willing or able to close.
Right.
And so once the buyer's in anticipatory breach, the seller must relist and mitigate damages. The idea of the mitigation of damages is you can't wait a certain period of time and let damages double or triple. That wouldn't be fair to the buyer. You need to essentially do what you can to limit those damages as quickly as possible.
Right, and list as soon as possible.
Exactly. So relist, sell the property for fair market value, and then start accounting for your damages. And so in Ontario, we don't typically see damages that will enrich the non-breaching party. Damages are there. Essentially, it's the cost of that party's breach. You're calculating the cost of that party's breach. So in that circumstance, the more obvious damage incurred by the seller would be the difference between purchase prices.
Value. Yeah.
So you sold for $5, you're now selling for $445. Well, that $35,000 difference, or that $55,000 difference, forms part of your damages.
And the cost of relisting. And
cost of relisting, if you have to restage, if you have to, your legal fees, everything falls into that scope. What I educate my clients on often, especially on the sale side when they're non-breaching, is you need to also factor in how long it'll take you to claim those damages against the buyer, go to court, get an order, enforce that order, collect those fees. You're talking about years. So,
which is so unfortunate because that's a.
Unfortunately, there's a big difference between what is legal and what is practical, and so I educate my clients on that. Lawyers do have an obligation to encourage parties to settle, and so I have to fulfill those professional obligations as well. But I just educate my client. These are the options, and so it may be in the seller's best interest to settle for a lower amount, have that amount dispersed partially from the deposit that's in trust with the listing brokerage, and then partially probably in cash from the buyer from the fund set aside for their down payment. That's usually the solution that provides for a quick settlement, the release of the deposit, and then remediation of some of the damages of the seller's incurred.
And that's good to know because it's peace of mind for the seller knowing that, life goes on for a lot of cases, right? If this is a dragged on for 2-3 year process, that's super stressful as well. Right?
Exactly. So. And the sellers out there that do have a purchase transaction pending, that was an issue for us a few years ago, and it still remains an issue. But suing a buyer and waiting 2-3 years for funds won't fix your obligations on a separate contract.
Or the interim emotional damage of not having those proceeds as well.
Exactly,
right?
Exactly. And so more often than not, it's worth being reasonable on the sale side and considering what it is that the buyer is able to provide upfront right away in order to move on and kind of put that botched transaction behind you.
And then we actually came across this in one of my early cases working together collaboratively as well. Can you coach our viewers and clients in terms of advice you provide from the buyer perspective? If, say, for example, they come across something on a final walkthrough. Mm-hmm. They purchased a home, they fulfilled their conditions, and then now they come across something during walkthrough that was not how the home was before. Simply not how it was before, right, when they agreed to purchase. So say something scratched, the hardwood's broken or scratched, right? How would you go about that, and how does that usually play about amongst the lawyers?
The big thing really is documenting everything. What I've been coaching clients to do recently is take pictures, take videos. Essentially, if you're buying and you want to take the position that the property is not in the same state, you need to provide evidence. You can't just claim that a certain appliance is no longer working, or there's damage to the property that was caused by the sellers during the moving period. And so providing evidence is usually number one. Number two, you need some form of breach of contract on the seller's part. So if the seller is representing that all the appliances are in good working condition, they're not on closing, then you have some form of recourse there. Or if the seller is, again, claiming that their tenant would be out of the house, they're no longer out of the house, then there would be recourse there as well. The list goes on, but typically the best way to handle that situation is document everything, communicate with your lawyer. The lawyer will negotiate some form of settlement with the seller's lawyer, but that's just subject to their approval. And so buyers need to understand that they have to close in most cases. A malfunctioning dishwasher isn't grounds not to close your transaction. You have to close and then sue for damages post-closing. And so retaining a lawyer that understands those rules, and then I can probably advise you. Ironically, as a buyer, you can be in breach of your agreement of purchase and sale if you refuse to close for a reason that doesn't justify it. And so retaining a lawyer that understands those rules is very important. And also being as reasonable as possible. Hopefully the seller does agree to a holdback, for example, to set aside some funds, get the dishwasher fixed, maybe get like the house professionally painted if the walls are in really rough shape due to the move. Sometimes we see sellers leave garbage at the property, and so garbage collection, the list goes on and on. It really can be anything. But I think what I try to coach my clients is, like, as a buyer, you have to be reasonable. As a seller, if they're in breach of their agreement of purchase and sale, it is in their best interest to negotiate some form of holdback so that they don't deal with a post-closing claim for damages in the small claims court.
Right. And does that usually play out quite often in terms of small claims court, if they pursue it? And
I've seen that a few times. I had a buyer buy a property with a pool during the winter, couldn't inspect the pool, which was a strategic error in my opinion from the outset. But as soon as the spring came around, that was post-closing, got the pool inspected and got two different opinions that the pool was in very rough shape. We're talking about like $24,000, $25,000 worth of damages. Yeah. And so in those cases, you need to be able to show the courts that those damages existed prior to closing. Because those reps and warranties on pools and chattels and appliances, they apply to the state of the property and they survive closing, but they only apply to the state as of the closing date. So if you're unable to prove to the court, to the judge, that the damage occurred before closing, you don't have recourse. All right, so again, documentation, pictures, videos. Ideally, you can compare those with maybe the marketing pictures of the property, to show that the state of the property is different. Obviously, an inspection is important, but people need to understand that inspections are visual, right? You can't open up a wall to see if there's mold there, and there's alternative solutions, moisture tests and stuff like that. But the best way a buyer can protect themselves is to go through those steps, understand them, ask questions from their inspector, ask questions from their realtor, from their lawyer. And then hopefully, if something's wrong, the seller does agree to a holdback, rather than forcing them to claim damages post-closing.
Gotcha. That's super helpful because I feel like that's a gray area that a lot of buyers are perhaps not coached on and not aware of. So that's awesome. In today's marketplace, with prices where they are and affordability being a real hurdle for a lot of prospective first-time homebuyers, we're seeing more and more the reality of looking into co-ownership and partnering up, right? And whether that's with a relative or a friend. Can you provide a few tips in terms of, from a legal perspective, how to protect yourself if looking to explore that option? And anything to be cognizant of when you're looking into the prospects of buying and then one day selling as well? How would that look like?
Yeah, for sure. I mean, the first thing you need to figure out is, what's that venture looking like? Are you buying with a family member? Are you buying with a friend? Are you buying through a corporation or with your personal name? What are the percentage of ownership? Who's getting equity? How are you splitting up the expenses once you close on the property? Are there options to buy out your partner eventually? Those are all items that a client should be coached on when they're exploring even the option of buying real estate with someone else. You can take title as joint tenants or as tenants in common in Ontario. Joint tenancy it doesn't have a percentage of ownership. You own it jointly with your joint tenant, and then you benefit from the right of survivorship. If someone passes away, the interest in that deceased individuals in the real estate is then transferred or vested with the survivor. Right. So you see that for couples, married couples. Tenancy in common is a percentage of ownership. That's typically what you see for joint ventures. So, for example, 50-50, two investors buy real estate together. But the issue with that is you're relying solely on what appears on title. There's no underlying document that provides for death, disability, buyout, sale of the property. Essentially, you need your tenant in common to agree with you if you want to do something with the property. It's not in every circumstance that you need that consent, but assuming that you have a mortgage on title as co-borrowers, that it would block an individual sale of that interest. Absolutely. And so my recommendation really is, okay, well, the options there is, co-owners agreement, co-ownership agreement. You could incorporate a corporation, have a shareholders agreement in there. There's a ton of solutions. What you need to know as a buyer is what's the deal between you and your partner. Get coached on the worst case scenarios, be prepared for that, and then hopefully the venture is successful and you never need to resort to that co-ownership, to that co-owners agreement, or to that shareholders agreement.
Right. No, that's awesome. That's good to know, because I think that for a lot of buyers, even friends have asked you in terms of the prospects of, maybe they're not looking to buy with a significant other, but looking to buy with a friend and at least get into the market. It's good to know kind of what to be cognizant of and kind of where the line lies of shareholder, right? Mm-hmm. So that's good to know. Just in wrapping up, like I said, you guys and your team, we've been very fortunate to work with a lot of first-time homebuyer files. Do you have any kind of last thoughts or tips on if you had maybe 2 takeaways for first-time homebuyers to really be cognizant of before looking to a real estate purchase?
Yeah, absolutely. Number 1 is hire a team you trust, follow their advice. Although your parents' advice is good to listen to, times have changed a lot. I think education is the most important part of it. Find a team that can educate you on how things have changed, how prices have changed. Bring your parents along, because the worst thing that can happen for a first-time home buyer is advice with your professionals and then having your parents not be on board and having those issues arise as you approach closing.
Conflicting opinions.
Conflicting opinions, exactly. You want this to be a positive experience. It's an exciting yet stressful process, but it is very exciting to close on your first property. I think the feeling you get when you walk into your place for the first time that you own is very special. So you don't want that clouded by, issues with your loved ones or issues with the team of professionals you hired. I think understanding the landscape and understanding your responsibilities and what you can expect from your professionals, kind of circling back to like one of our first topics today, is as long as you understand what's going on and your team understands where you're coming from and your priorities, it should make the entire process much easier, much more enjoyable. Yeah. And again, like, you want that wow feeling when you walk into your first property.
That's awesome. Cool. Well, thanks so much for your time, Alex. We appreciate it. And we look forward to helping a lot more first-time home buyers in the future.
My pleasure. Thanks for having me.